Good morning and welcome to the 20th Keating Chambers webinar of 2020. For those of you who don't know me, my name is Marie Sparks and I'm the BD and Marketing Manager at Keating Chambers. As this is the last webinar of the year, I'd like to thank you all for tuning in over the last 8 months. We've had live audiences of up to 500 people and I know a lot of you have also been tuning in at a later date on YouTube. It really does mean a lot to us. So now it's my pleasure to introduce 3 excellent Keating juniors who are providing today's construction law case update. First up is Harriet Francesco, who will be discussing the Court of Appeal decision on payment notices under hybrid contracts. James Frampton will then follow with a look at adjudication versus insolvency and the cases of Francesco and John Doyle. And Harry Smith will close the webinar with a review of true value adjudications. Where are we now? So without further delay, I'll now hand you over to Harriet.
Hi everyone, I'm just going to share my slides with you. Thank you for joining us. It's my first webinar of the year and it's great to be here. I'm going to be talking about payment notices under hybrid contracts and the case specifically of C. Spencer Limited and MW High Tech Projects UK Limited, or CSL and MW. This was a Court of Appeal decision of March earlier this year. Now, the implications of this case, admittedly, are not as far-reaching as Francesco or the other cases that Harry and James will be discussing shortly. However, it does deal with an issue which had never arisen for decision before. Should you come across a dispute relating to adjudication or payment under a hybrid contract, hopefully this will be a helpful introduction and a case to refer to. Now, by hybrid contract, I mean a contract that relates to both construction operations within the meaning of Section 105 of the Housing Grants Construction and Regeneration Act 1996 and non-construction operations which are excluded from the Act. Now, for those who are not familiar with the Act, and there may be some of you joining us today, Part 2 of the Act applies to construction contracts. Now, that is contracts which relate to construction operations. Construction operations are defined under Section 105(1) of the Act, and in essence includes everything any reasonable person would consider as construction or builder's work, except for the matters which will be excluded, which I'll come on to shortly. It includes, for example, painting and decorating. Part 2 of the Act sets out certain mandatory provisions relating to payment and adjudication, which construction contracts, generally speaking, must comply with. Now, as I mentioned shortly ago, unfortunately, one of the rather illogical and uncommercial aspects of the Act is the exclusion of the following activities from the Act under Section 105(2). Now, these exclusions relate to the process or energy production industries predominantly. It's been said that the government, when drafting the Act, was got at by some big, powerful, important interests within those industries who are now effectively exempt from the requirement to, for example, make interim payments, give notice as to what payment is considered due, and the right to refer disputes to adjudication, which was an important matter in this case. Obviously, the parties can agree to those things in their contracts, and they are advised to do so, especially in a hybrid contract where certain matters can become quite complicated, as they did in this case. Now, the complications arise from Section 104(5) of the Act, which provides that where a construction contract relates to both construction and non-construction operations, the Act still applies, but only applies to those parts of the contract which relate to construction operations. Now, this can make matters very complicated, particularly where the parties haven't made provision in their contract for each party to refer a dispute to adjudication, or, for example, where the contractual payment mechanism doesn't comply with the Act. Now, in those circumstances, the parties may find themselves with 2 separate payment mechanisms, one governed by the contract in respect of non-construction operations and one governed by the Act in respect of construction operations. They may also find themselves in a difficult predicament when trying to refer a dispute to adjudication. This can be difficult if the parties haven't made provision for them to do so in the contract, because the adjudicator won't have jurisdiction to determine the dispute if they haven't. Now, from time to time, the implications of this can rear its ugly head, as it did in CSL and MW. Now, a brief summary of the facts of the case. MW was the main contractor engaged to design and build a power plant capable of processing refuse-derived fuel produced by waste. MW engaged CSL as subcontractor to design, construct the civil, structural and architectural works in return for a hefty sum of £35.5 million to be paid according to milestones. Now, the subcontract works, as you may have noted, related to both construction operations and non-construction operations, because elements of the work were to be carried out on a site where the primary activity was power generation. It's therefore a hybrid contract. The contractual payment mechanism in the subcontract complied with the mandatory provisions of the Act. The payment provisions applied equally to both construction and non-construction operations, and it did not require the parties to separate out construction operations from applications for payment and payment notices. Now, during the course of the project, the parties only ever identified a single sum. Importantly, there was an adjudication clause which only gave an adjudicator jurisdiction to deal with the dispute insofar as the Act allowed him to. Now, naturally, as these things happen, a dispute arose over an interim application for payment. CSL referred that dispute to adjudication under the Act. MW, rightly, challenged the adjudicator's jurisdiction on the basis that CSL's application for payment, the notice of adjudication, and therefore the dispute referred to him, did not distinguish between construction and non-construction operations, and therefore he did not have jurisdiction to deal with the dispute pursuant to the adjudication clause in the contract. Now, CSL withdrew its adjudication and clearly took something from this experience, because it issued a fresh application for payment, which allocated a sum for construction operations only. MW responded with a payment notice, which didn't separate sums out, and it claimed, in fact, a negative balance of almost £7 million. CSL commenced Part 8 proceedings, and those were the first instance proceedings in this case, in respect of the sum claimed in its application. It claimed that MW's payment notice was invalid because it did not allocate a sum for construction operations only, as it had done in its application, and it based its argument on the fact that it said that the Act implied a term that required parties to hybrid contracts to provide separate sums for construction operations and their payment notices, and that ultimately this was the practical thing to do in their submission. Now, the issue for the court in the Part 8 proceedings was whether, under a hybrid contract, a valid payment notice must identify separately the sum due in respect of construction operations only, along with the basis on which that sum had been calculated. Seems like a very simple question. It's one that Mrs. Justice O'Farrell found in the negative. She held that where a hybrid contract contained a payment scheme that complied with or mirrored the relevant provisions of the Act, and that payment scheme applied equally to both construction and non-construction operations, as in this case, that a payment notice did not need to distinguish between construction and non-construction operations, and it was capable of being valid if it didn't. Now, I won't go into detail the reasons she gave, but in essence, she said that there was simply no requirement to do this, either under the subcontract, as was common ground in this case, or under the Act. A very simple answer to a very simple question. On appeal, the appellant argued that the judge had erred in her interpretation of the Act. It argued, as it had at first instance, that the words "only insofar as it relates to construction operations" in section 1045 should be read into all the later sections of the Act, including those relating to payment notices. Lord Justice Coulson, however, agreed with Mrs. Justice O'Farrell. He was also quite critical of the Act and the argument that separating sums in this way was the practical thing to do. He commented that the Act already creates very problematic situations by, firstly, distinguishing between construction and non-construction operations, and secondly, by applying to hybrid contracts in the way that it does. If the appellant was right and a distinction had to be made, this would actually create all sorts of layers of complexity and cost, which was simply not envisaged by the payment provisions of the Act, and indeed would be contrary to the whole purpose of it, which was to create a simple and prompt system of payment on construction projects. So what are the practical implications, if any, of this case? Well, as with most of these disputes, it really depends on the terms of the contract. Generally speaking, if a payee under a hybrid contract wishes to make a claim for payment in respect of construction operations only, or indeed wishes to bring a dispute to adjudication, it may be necessary for the payee to separate out those sums in its application. But absent any term to the contrary, the payer is under no obligation to do the same. There is therefore potentially a greater burden on the payee, and ultimately a far more limited scope for smash and grab adjudications. Ultimately, parties to a hybrid contract, specifically those who are likely to be the payees, should seek to either agree an adjudication clause, or indeed they should seek to agree an adjudication clause, which allows them to refer any dispute under the contract, and preferably also agree payment provisions which comply with the Act to avoid complications. A final interesting procedural point, in circumstances where the payment provisions under the Act do not comply with the Act, as I said earlier, under the contract, sorry, do not comply with the Act, there would effectively be two payment processes, one which applies to construction operations and one non-construction operations. In order to determine whether a party is entitled to payment in those circumstances, a court would have to determine as a matter of fact which elements of the works were subject to the Act and which were not. Such a fact-finding exercise is unlikely to be suitable for Part 8 proceedings and would be more suitable for Part 7. And the point in this case was academic, since it wasn't necessary for the court to do that. But in any event, might be helpful for those who find themselves embroiled in such a dispute. I hope this has been at least a helpful introduction to payment disputes and adjudication under hybrid contracts for those of you who haven't really had the pleasure of dealing with one yet. And I'll be moving now on to my final slide, and James will be taking over. Thank you.
Thank you, Harriet, and hopefully you can all hear me and see my slides. So I'm going to be looking at, for the second topic of today's webinar, insolvency and adjudication, particularly looking at the cases of Bresco in the Supreme Court, and then the following case of John Doyle. And there are really three broad topics I'm going to be touching on. Firstly, looking at the history of Bresco all the way from first instance to the Supreme Court. Secondly, looking at the enforcement decisions following Bresco, particularly John Doyle. And briefly to close, just to consider where we stand on set-off in adjudication. So to start with Bresco, I've set out the basic facts here. And the key points are that Bresco was in liquidation and that Lonsdale didn't wait for a decision or enforcement. Instead, they sought to get a preemptive strike. They issued an application in effect for an injunction to stop the adjudication before it really got off the ground. And at first instance, all the way back in 2018, Mr. Justice Fraser granted that injunction, and he did so on grounds that the adjudicator didn't have jurisdiction. And this was an application of the insolvency rules, which make provision that where once one party goes insolvent, there is an automatic set-off of cross-claims between the company in liquidation and its creditors, giving rise to a single net balance, which is to be ascertained by an account. And in effect, Mr. Justice Fraser's reasoning was, well, the construction claims or disputes disappear. There is a single dispute as to a net balance. And he said, well, that's not a dispute or a claim under a construction contract. And Bresco was unhappy with that reasoning, and it appealed. And in the Court of Appeal, Lord Justice Coulson, he disagreed with Mr. Justice Fraser. He found the adjudicator did have jurisdiction, but he said that was just the start of the exercise. And he went on to then look at the utility or practicality of an adjudication in these circumstances, and said that generally it would be an exercise in futility because it would not be enforceable. And it was on that basis he upheld the injunction. And again, note, obviously, it's not a case on enforcement, it's dealing with it at the start. And Bresco was unhappy with this revised wording and appealed again to the Supreme Court, and Lonsdale cross-appealed. So both arguments were in front of the Supreme Court, the jurisdiction point and the utility point. And Lord Briggs, who gave the leading judgment in the Supreme Court earlier this year, rejected both, as we'll come to see. So first, he rejected the jurisdiction argument on the basis that while practically there may be a single netting off, he said the individual disputes didn't simply disappear. They still existed for some purposes, which would include adjudication, even if they didn't exist for others, such as you cannot assign the separate disputes. So he rejected Mr. Justice Fraser's conclusion, and he then also rejected Lord Justice Coulson's conclusion that an adjudication by company liquidation was futile. And you can see his reasoning here. On that reason, he didn't uphold the injunction. And the key reasons on which Lord Briggs reached this decision are set out on this slide. And A is the fact that normally an injunction is to stop a threatened breach of contract. And the Supreme Court didn't see why ordinarily the court should injunct a threatened exercise of a contractual right or statutory right. And secondly, he emphasised that adjudication was not just about cash flow. And in fact, actually, history has shown us that adjudication has become an effective final resolution of disputes. Although it may be classed as interim and binding, parties often don't bother going to challenge it in court if they think they've got a fair enough or reasonable enough decision on the point. And thirdly, he held it wasn't incompatible with the insolvency process because the adjudication of disputed construction claims by adjudicators, experts in the area, can assist insolvency petitioners and the parties to resolve the overall account. So for those three reasons, the Supreme Court dismissed the injunction, but significantly, it's not to be overlooked that Bresco made clear that while the adjudication could continue, parties in liquidation could still face difficulties on enforcement. So it didn't dismiss the concerns on which the Court of Appeal reached its decision, but rather made clear that those concerns first set out in Boyg and Dow Jensen were issues for enforcement. They weren't issues to stop the adjudication. The court would deal with it all at enforcement once there was a decision. But given this wasn't a case on enforcement, beyond the brief guidance on this slide that enforcement won't always be declined, and the key is whether the security will be deprived. And Bresco didn't really give guidance on what circumstances then would enforcement be given or not given. So since Bresco, happily, two cases have sought to fill this gap. And the particular is the one I'm going to focus on first. So the first one is I want to focus on particularly because it's perhaps the most helpful. That's John Doyle. And again, I've tried to set out the key facts of John Doyle on this slide. And the important point again is that John Doyle was in liquidation before it commenced the adjudication. It was then successful. There is also a point which was touched on the judgment that this was all a very long time ago. And Mr. Justice Fraser did wonder whether adjudication was suitable for disputes which had arisen so long ago. But the important part of the decision is the list of factors or principles which Mr. Justice Fraser set out on which the court would apply when deciding whether to enforce when the referring party is in liquidation. And I'm going to look at each of these in more detail. So the first, does it resolve the party's financial dealings under the contract, i.e. is it a termination account or final account? And this should obviously also, in my view, involve a situation where you have multiple decisions. So as long as all the decisions put together resolve the account, and then you enforce them all at the end. Secondly, factor is whether there are mutual dealings outside the construction contract, and I'll return to that point later. Point three is, are there other defences available? And really, this is largely the same point as point two, because it would appear odd if the party could benefit on enforcement from not raising defences in the adjudication. In other words, it very much should be, are there other defences which you could not deploy in the adjudication, which you could now deploy? The fourth point is whether the liquidator is prepared to offer appropriate undertakings. And this was the main point in John Doyle. And the security or the undertakings are primarily for the principal sum, but they're also for costs. Because if you, as a responding party, pay out on a claim to a party in liquidation and then bring your own court claim to recover those sums, one irreversible prejudice you've suffered is you're not going to be able to apply for security for costs because you are now the claimant in the court proceedings rather than the defendant in the court proceedings. So in effect, points 4 and 5, as we'll come to look at, are kind of putting in a regime for security for costs at the enforcement of the early adjudicated decision stage. And factor 5 really is the principle to which point 4 goes to. Is there a real risk you'll lose security for the cross-claim? And one important point I've highlighted is that from Bresco, the Supreme Court made clear that a cross-claim can include a dispute on the claim already subject to adjudication. So the cross-claim you can rely on is that we don't agree with the adjudicator's decision, we're going to go to court and seek to get it overturned on the substance. So in reality, there is always going to be a cross-claim. Mr. Justice Fraser then sought to explain in what circumstances, applying those factors, a decision in favour of company liquidation would be enforced. Point 1, as we've discussed, so does it resolve all the financial dealings, is clear. And point 2 is mutual dealings on other contracts or other defences, if they have not been taken into account by the adjudicator. And I'll return to that part, to the if, but not taking account by the adjudicator later. But the deal with the part, firstly, to deal with the next point the party says, which is will be taken into account by the court on the summary judgment application. Obviously, the uncertainty here is what does this mean? What does taking it into account mean? And the suggestion, by reference to the quotation from Lord Briggs, is that taking into account will simply mean, or may simply mean, the cross-claim is accepted in full and judgment entered on the balance. Now that may be fine if you have a claim for £100,000, say, and the cross-claim for £5,000. You get your £95,000 balance. But what about if the cross-claim is for £95,000? It is a bare allegation of a cross-claim enough to reduce the adjudicator's decision in effect to £5,000. If we go back to slide 9, the answer to bare allegation would seem to be no. Paragraph 65 of Bresco made clear that on enforcement, the court could find that the disputed cross-claim may be of no substance, but it's difficult to think that an enforcement hearing in the TCC can sensibly become a summary judgment hearing of an unmade cross-claim, particularly if it's not a construction claim. So I suggest it's probably unlikely to be in the very clearest of cases that there is no substance whatsoever, that the cross-claim could simply be dismissed. So again, we're left with perhaps a slight uncertainty as to, well, if the cross-claim is very large and not completely hopeless, what does taken into account mean? And point 3, Mr. Justice Fraser's decision in John Doyle, the real risk, whether it be new security for its cross-claim, that was the focus in John Doyle. And in that case, Mr. Justice Fraser held that the security was insufficient and therefore refused to enforce a decision on that grounds. 2 reasons. Firstly, he said the purported letter of credit was in fact a letter of intent. And secondly, the ATE insurance for costs was subject to exceptions and therefore the risk of being avoided. Obviously, if you are going to an enforcement hearing where these types of detailed points arise, I would encourage you to read John Doyle and how it deals with them in detail. But there's not sufficient time for this talk. But ultimately, the conclusion was that there was a real risk that Erith would be deprived of security for its cross-claim. And on this factor of the real risk of losing your security, it's also helpful to consider Stiles and Wood, which is a Central London County Court decision. And again, the key facts are on this slide. And the offer to ring-fence the principal sum was accepted and uncontroversial. The key issue was the ATE policy, in particular whether a policy for £200,000 of costs was sufficient, with Dee saying, well, our arbitration costs are actually likely to be £800,000. And the court accepted the analysis by the claimant that, and basically in effect carried out a cost budgeting exercise of what the likely cost of the arbitration would be, and came to the decision that it'd be closer to £200,000. So it's notable for the analytical approach the court adopted to the responding parties, or party resisting enforcement's claims. And ultimately, for those reasons, His Honour Judge Parfitt granted the summary judgment without a stay on conditions that A, the ring fencing applied to the sums paid over until the conclusion of appeal, and B, there was the ATE policy at £200,000. So in that case, summary judgment was granted. So to return and draw the threads together on this part of the talk, and looking again at the circumstances in which Mr. Justice Fraser said the court would enforce a decision in favour of a company in liquidation, I've tried to add my brief assessment in bold of where I think we stand. Firstly, does the decision resolve all the different elements of the financial disputes under the construction contract? Well, I think that's, as I said earlier, self-explanatory, save for set-off, which I'll come to look at. Secondly, mutual dealings on other contracts or other defences will be taken into account. As we looked at, it's unclear how it will be applied in practice. One potentially likely order, unless the cross-claim is wholly without merit, will be an enforcement with a stay of execution, giving the responding party a reasonable period of time to commence proceedings. Maybe a particularly short period if the court isn't particularly impressed by the responding party's claim or the time it's taken to bring the claim thus far. But that's one thing I could see the court doing. Put it glibly, a put up or shut up style order. And that is perhaps a key point on which parties will require further guidance from the court. Factor 3, the real risk of losing security for your cross claim. Well, this I think is where we already have the most guidance. There is John Doyle and Stiles and Wood, which we've looked at. So John Doyle on letters of credit and the ATE policies, and Stiles and Wood on the amount of costs. And there is also Meadowside, which is a pre-Bresco case of Adam Constable QC. We're looking at detail in undertakings. So that's, I think, where we stand on the position of enforcement. As I say, it's number 2, I think, which is really requires further guidance. But briefly to end my talk, I would like to consider another issue of interest, which I think arises from Bresco, and again, probably requires further clarification. And that is the availability of set-offs as a defence in the adjudication itself, i.e. before you get to enforcement, thinking about during the adjudication. And it's helpful to, I think, break set-offs down into 3 categories. So it's set-offs under the construction contract, set-offs under another construction contract, and then set-off for a non-construction claim. So the first category, and so a set-off under the construction contract should be available generally as a defence to a true value claim for payment. And as Bresco confirmed, however narrowly the referring party chooses to confine the claim, and I think we all have experience of notices drafted in a particular way to argue that anything else is excluded, cannot exclude anything which may be properly advanced as a defence. And obviously I refer to a pay less notice here because one important point is that if you do try and raise a set-off, an adjudicator could say, well, you cannot raise that set-off because you haven't issued a pay less notice for it. That is the adjudicator dealing with it on the substance. And even as a matter of law or fact, he's wrong, the court will enforce the decision. But the adjudicator generally cannot simply say, if it is a proper defence, no, I don't have jurisdiction to consider it because it's outside the notice. And on this point, there's also helpful guidance from the TCC decision last week in Global Switch, where in effect the referring party sought to refer a dispute on parts of valuation. The responding party sought to rely and sought an order for payment, crucially. The responding party sought to bring in the value of other items of the valuation. The adjudicator said he couldn't consider other parts of the valuation. And the court said, given that he was ordering payment, the adjudicator was wrong and in breach of natural justice for doing so. So set-offs under the construction contract generally should be available subject to the pay less notice point and whether in law it's a true set-off. And certainly liquidation, I think, must be considered because otherwise you're not resolving the overall financial dispute under the contract. So company in liquidation is going to want the set-offs determined. The second category is set-offs under another construction contract. And this is really where I think the interest in this topic comes from Bresco, because there is very much a suggestion in Bresco that set-offs under another construction contract are available as a defence. First of all, it says, well, the scheme gives you can grant consent for the adjudicator to deal with it. But goes on crucially to say in reality it may be a single dispute, so may not need consent. Notably, as I say, John Doyle seems to take a different approach, and saying that, well, the adjudicators shouldn't take on matters outside the construction contract singular. So I think further clarification is required residing those two. But assuming Bresco is as the Supreme Court decision sets out the principle, the question comes, does this only apply if the referring party is in liquidation, or is Lord Briggs talking more broadly? There is a suggestion that he's only talking about claims in liquidation. So 46, he refers to a dispute about a cross-claim relied on as a set-off. Cross-claim very much talking in language of insolvency. But there are two possible factors I would leave you to consider. Firstly, a set-off clause in the first contract. If you have the right wording on a set-off clause in your first contract that you can rely on set-offs under other contracts, does that in effect bring in the set-off as part of the dispute under the first contract? And secondly, what about if you've already raised the pay less notice under the first contract, relying on your set-off under the second contract? If the adjudication is a claim for payment, which is in effect the true valuation of the application of pay less notice, hasn't the pay less notice already brought in that set-off as part of that dispute? So that on those grounds, and potentially even more generally, it may be that set-offs under other construction contracts are more readily available as a defence in the right circumstances than parties may, and particularly adjudicators, may consider. The final category, which I think is perhaps less problematic, is set-offs unrelated to a construction contract, i.e. not under any construction contract. I think if you're not dealing with insolvency case, they're unlikely to be available. They're likely to be outside what would be a common law or equitable set-off. But if you are in an insolvency case, again, the suggestion in Bresco is that it may be a defence the responding party can raise, because it does say here the adjudicator will need to have regard to them. That is significant. But it does then goes on to say, but they may simply have to make a declaration as to the true value of the claim. What it's saying there is, rather, if it's outside the adjudicator's expertise, they have to consider the set-off. But rather than reach a decision on it, it impacts the remedy the adjudicator can grant. So rather than granting payment, if there is a set-off raised, for example, a personal injury claim, the adjudicator's response should be, well, I can't deal with that. That means I cannot order payment, but I'm going to make, so instead I'm just going to make a declaration as to the value of the claim under the construction contract. And as the case of Global Systems last week highlighted, there is an important difference between those two types of relief. Not least, of course, if you only have a decision on the value of the claim, you're not going to really be able to go to court and enforce it to seek payment. So overall, as well as whether you can bring an adjudication when you're insolvent and also enforcement, Bresco does give rise to further consideration, I think, of where we stand with set-off in adjudication. And overall, I think it shows that set-off is perhaps more available than parties, and particularly adjudicators, may currently believe. And further guidance is probably required from the TCC to confirm what set-offs in what circumstances can be raised. And a couple of points I would leave you to consider is that if you're a referring party in liquidation, you may actually want to encourage or even say your consent to the responding party putting it set off before the adjudicator. Because if you think it's hopeless, because then the adjudicator can determine it in your favour, or if they refuse, on enforcement you say, well, they had their chance and they said no. And if you're a responding party, you may want to think again whether or not the referring party in liquidation is whether you have a set-off defence which you think you can deploy, and potentially, if ignored by an adjudicator, becomes good jurisdictional defence for you on enforcement. So I'm now going to turn over to Harry, who's going to look at Grove, following cases following Grove, and also whether Bresco has an impact on the reasoning in Grove as well. Thank you very much for listening.
Okay, well, I hope you can all see my slides. If you can't see me, my slides, or hear me, hopefully somebody will let me know. Well, you've had your aperitif, ladies and gentlemen, in the form of Harriet talking about hybrid contracts. You've had a substantial main course in the form of James talking about Bresco. So it must be time for some dessert. And that's where I come in. So I'm going to be bringing things to a close here by bringing you bang up to date on the topic of true value adjudications. The leading case, as many of you will know, is the decision of the Court of Appeal in S&T and Grove, which was handed down back in late 2018. And what I'm going to do is give you a brief reminder of what Grove decided, and just as importantly, what it didn't decide, and then look at what's happened since then. And the particular question I'm looking at here is the circumstances in which an employer will be permitted to commence a true value adjudication. That is an adjudication to determine the true value of a particular payment due under the contract, as distinct from a smash and grab adjudication, which determines the extent of an employer's liability to pay the notified sum due under section 111 of the Construction Act. So in S&T and Grove, the contractor S&T made an interim application for £14 million. Grove issued a pay less notice showing a sum due of 1.4 million, so quite a significantly lower sum. And an adjudicator found that Grove's pay less notice was invalid, and so decided that S&T was entitled to be paid the full 14 million stated in the interim application. S&T applied to the TCC to enforce that decision, and Grove responded by seeking various declarations, one of which, importantly, was a declaration that, notwithstanding the outcome of the first adjudication, Grove was entitled to commence a fresh adjudication to determine the true value of the interim payment due to S&T under the contract. And at first instance, Mr. Justice Coulson held that Grove was so entitled, notwithstanding the absence of a valid pay less notice. But this gave rise to a problem. If an employer is free to try to overturn the decision in a smash and grab adjudication by starting a true value adjudication, what is there to stop him from doing that without first paying the sum found to be due in the smash and grab adjudication, and thereby dodging the consequences of his failure to issue a pay less notice altogether? And it's clear from the first instance judgment that Mr. Justice Coulson, as he was, spotted this problem. He didn't answer it directly, but he heavily implied that in those circumstances, an employer would not be allowed to start a true value adjudication without first paying the notified sum. And we see that in the three quotes that I've put on the right-hand side of the slide. So he said, the employer has to pay the sum stated as due and could thereafter raise the question of the true valuation in a subsequent adjudication. Following payment of the sum stated as due, the employer should be able to commence an adjudication as to the true value of the interim application. And finally, the adjudications will still be dealt with by adjudicators and by the courts in strict sequence. The second adjudication cannot act as some sort of Trojan horse to avoid paying the sum stated as due. I have made that crystal clear. Whether Mr. Justice Coulson had in fact made the position crystal clear in his judgment, and whether the metaphor of a Trojan horse really works, both perhaps questions which are open to some debate. But on any view, what he did not elucidate was any legal basis for his conclusion that an employer could not start a true value adjudication without first paying the notified sum. So that brings us on to the Court of Appeal. And in the Court of Appeal, Sir Rupert Jackson upheld Mr. Justice Coulson's decision in the result, but he developed the analysis quite considerably. And he said, in an important extract, which I've put on the slide, effectively the Construction Act creates a hierarchy of obligations. The immediate statutory obligation is to pay the notified sums set out in section 111. As a matter of statutory construction and under the terms of this contract, the adjudication provisions are subordinate to the payment provisions in section 111. Both the Act and the contract must be construed as prohibiting the employer from embarking upon, and you see I've emphasised those words, embarking upon an adjudication to obtain a revaluation of the work before he has complied with his immediate payment obligation. And the broad thrust of that reasoning is, I think, is a convincing and is generally accepted as such, I think, by the legal community. But there is a difficulty, and it concerns the words I've underlined on the slide, embarking upon. What Sir Rupert is saying there is that an employer will not be permitted to start an adjudication to obtain a true valuation of the interim payment until the notified sum has been paid. And it's clear from the judge's language, he says that the Act prohibits the employer from embarking upon an adjudication, that he regards this as a matter which would go to the adjudicator's jurisdiction. And it's very difficult to reconcile that proposition with the wording of section 108(2)(a) of the Construction Act, which, as most of you will know, provides that parties have a right to start an adjudication at any time. The meaning of the words "at any time" might be thought to need no elucidation, but for the avoidance of any doubt, and I'll put this on the right-hand side of the slide, the Court of Appeal confirmed in 2005 that the phrase "at any time" means exactly what it says. So that's Connex and Building Services Group. And as you can see from that slide, the court also noted that it was apparent from Hansard that Parliament had considered the time for referring a dispute to adjudication specifically, and had decided not to provide any time limit. So there is, I think, scope for doubt about whether this part of S&T and Grove is right. So when I say this part, I mean the words embarking upon that part of the judgment. On the face of it, the more convincing analysis would appear to be that the courts should simply decline to enforce a true value adjudication decision unless and until the notified sum has been paid, rather than place any fetter upon parties' rights to start adjudications. That approach would achieve the same objective of upholding the primacy of the statutory payment provisions without doing violence to the clear words of section 108(2)(a) at any time. And in that regard, it is worth noting that whilst the Act is prescriptive about when you can start an adjudication, it's at any time, it doesn't say anything about how or in what order adjudicators' decisions are to be enforced. So there is a degree of flexibility there. And it's fair to say that the analysis I've just proposed is supported now to some extent by the judgment of Mr. Justice Stuart Smith in Davenport and Greer, which was handed down in February last year. So in that case, both a smash and grab adjudication and a true value adjudication had already taken place by the time of the enforcement hearing. And the defendant argued that it was entitled to rely on the true value decision to resist enforcement of the smash and grab decision. And Mr. Justice Stuart Smith projected that submission. He analysed S&T and Grove in some detail, and then he said this, and I've put this on the slide. It should now be taken as established that an employer who is subject to an immediate obligation to discharge the order of an adjudicator based upon the failure of the employer to serve either a payment notice or a pay less notice must discharge that immediate obligation before he will be entitled to rely upon, and I've emphasised those words, a subsequent decision in a true value adjudication. And I've highlighted the words rely upon because they indicate that it is on enforcement that the court will deal with the issue. So whilst Mr. Justice Stuart Smith did say elsewhere in his judgment that he agreed with Sir Rupert Jackson's reasoning in Grove, this aspect of his judgment does mark a departure from Grove, because it makes clear that, at least in the view of Mr. Justice Stuart Smith, an adjudicator does have jurisdiction to decide a true value adjudication in circumstances where the notified sum has not been paid. And Mr. Justice Stuart Smith then went on to address this point head on by saying this: the decisions of Mr. Justice Coulson and the Court of Appeal in Grove are clear and unequivocal in stating that the employer must make payment in accordance with the contract or in accordance with section 111 of the amended Act before it can commence a true value adjudication. And then I've emphasised these words: that does not mean that the court will always restrain the commencement or progress of a true value adjudication commenced before the employer has discharged his immediate obligation. See the decision of the Court of Appeal in Harding. It is not necessary for me to decide whether or in what circumstances the court may restrain the subsequent true value adjudication. And in these circumstances, it would be positively unhelpful for me to suggest examples or criteria, and I do not do so. Well, we might disagree with him about whether it would have been helpful. But this is nonetheless an important passage because it clarifies that notwithstanding S&T and Grove, the court does in fact have the discretion to permit employers to commence and progress true value adjudications without paying the notified sum in particular circumstances. And it must follow from that, I would suggest, that the prohibition to which Sir Rupert Jackson referred in Grove, and he did, as we saw, he used that word, is not on analysis a matter that goes to the adjudicator's jurisdiction. And therefore, employers are in principle free to start true value adjudications without paying the notified sum, subject to the risk that the court will, in the exercise of its discretion, restrain the continuation of the adjudication by injunction if it's asked to do so. And Mr. Justice Stuart Smith leaves us in the final sentence of the slide, as I've noted, with an open question about the circumstances in which the court will or will not exercise its discretion to restrain a true value adjudication, and he expressly declines to answer it. And that brings me on to this year. So the first case I want to look at from this year is Broseley London and Prime Asset, which was handed down on the 21st of April this year, and it's a judgment of Roger Tahar QC, sitting as a Deputy High Court judge. And the issue about a true value adjudication arose in a slightly odd way in this case. It was an application to enforce a smash and grab adjudication decision. Since that decision, the contract had been terminated and there had been an adjudication about that. The employer accepted that the contractor was entitled to a judgment enforcing the smash and grab decision, but argued that the execution of the judgment should be stayed for 2 months to give it time to have an adjudication about the true value of the final account post-termination. And the employer argued that Grove simply didn't apply in that situation because the proposed adjudication wasn't about the true value of the interim application, which had been the subject of the smash and grab. It was about a completely different valuation dispute following a termination of the contract. But the judge rejected that submission, and I've quoted the terms in which he did so on the slide. And the particular point to which I would draw your attention is the underlined words. The judge's argument being that permitting the true value adjudication to proceed would be a remarkable intrusion into the principle established in S&T and Grove. It would permit the adjudication system to trump the prompt payment regime, which is exactly what the Court of Appeal said would not be permitted to happen. Now, that reasoning is curious for a couple of reasons. First, there's no reason in principle, I would suggest, why merely permitting an adjudication to proceed would somehow in itself undermine the statutory payment provisions, particularly in circumstances where it is now clear beyond any sensible argument following S&T and Grove and Davenport and Greer that the employer will not be allowed to rely upon the second adjudication to defeat its obligation to pay the notified sum. And second, more generally, this judgment just seems to me to overlook Davenport and Greer. One might have expected the court to cite Davenport, note the existence of the discretion to permit true value adjudications to proceed without payment of the notified sum in certain circumstances, to which Mr. Justice Stuart Smith referred in his judgment, and to go some way to answering the open question posed by Mr. Justice Stuart Smith as to when the court will exercise that discretion. And that kind of analysis is wholly absent from the judgment. And I should say, I happen to know that Davenport and Greer was cited to the judge in this case. So it is quite surprising that it isn't dealt with. But standing back from that, on the face of it, this judgment does go some way to extending the scope of the cases in which S&T and Grove could successfully be invoked. And it will, I'm sure, be relied upon by contractors who wish to restrain true value adjudications brought by their employers without paying the notified sum. But I wouldn't be inclined to overstate its significance. The reasoning on this issue is not especially convincing, I would suggest, for the reasons I've given, and in particular because of the failure to grapple with Davenport and Greer. That said, permission to appeal this case was sought and refused. It involved an application. It was about a stay of enforcement, and the judge has a very wide discretion in such cases. So it's not surprising that permission was refused, but the possibility of it being appealed has been exhausted. So where does all of that leave us in terms of true value adjudications? Well, we know now that an employer cannot, in any circumstances, rely upon a true value adjudication decision to overturn the result of an earlier smash and grab adjudication decision. unless and until it pays the notified sum. That is the consistent message of Grove, Davenport, and Broseley, the trilogy of cases we've looked at. There is some conflict between the authorities about whether an employer is free to commence such an adjudication without paying the notified sum. But the better view, I respectfully suggest, is that an adjudicator appointed in those circumstances would have jurisdiction, but that the court would have a discretion applying Davenport to halt the adjudication by injunction on an application by the contractor if it saw fit to do so. That, of course, begs the rather large question, when will the court exercise that discretion? Well, the answer is that we still don't really know. One hint at a possible answer appears in the Court of Appeal's judgment in Bresco. Lord Justice Coulson approved an earlier case, Twintech and Volker Fitzpatrick, as authority for the proposition, and I put this on the slide, that the court will grant an injunction if the court concludes that the nascent adjudication is a futile exercise. This is an important power in the context of adjudication. And so it might follow from that, that if the court is satisfied that the proposed true value adjudication is a futile exercise, that an injunction would be granted. But it's at best very unclear how that principle stands after the Supreme Court's judgment in Bresco. Because as we know, having listened to James earlier, on one view, the whole premise of Bresco is that the court will restrain an adjudication if it will be futile. Lord Briggs' judgment is directed to rebutting the argument that adjudication by an insolvent claimant is futile. He doesn't suggest that a futile adjudication should be allowed to proceed. So there is a respectable argument that the principle remains intact. But the difficulty is that the reasoning in both Twintech and in Bresco in the Court of Appeal was based explicitly on the proposition that an adjudication will be futile if the decision will ultimately be unenforceable. That is precisely the ground on which the injunction was granted in Twintech. And of course, that is precisely the proposition which was rejected by Lord Briggs in Bresco in resounding terms. It is clear on any fair reading of his judgment that Lord Briggs did not regard his arguments about the utility of adjudications as being confined to the situation where the referring party is insolvent. He was of the view that unenforceable adjudication decisions generally have utility. And so in light of that, it's very difficult to know whether the statement of Lord Justice Coulson in Bresco in the Court of Appeal stands, and whether the court will be willing to hold that a true value adjudication is futile and so restrain it by injunction. On the face of it, the Supreme Court's judgment in Bresco seems to put quite a significant hurdle in the way of any argument to that effect. And so the final case, and the most recent case I want to look at, is Hugh Holdings and Donald Insel Associates, which was handed down by Mrs. Justice O'Farrell in the TCC on the 15th of July this year. And as I'll explain in a moment, it involves an original argument about true value adjudications. So the facts, well, this was a dispute about refurbishment of a private home, and Donald Insel obtained an adjudicator's decision in its favour to the tune of £208,000 and summary judgment enforcing the decision in February last year. Hugh failed to pay. So in March of this year, Hugh then commenced proceedings against Donald Insel, alleging professional negligence and breach of contract. Effectively, the effect of which was to seek to reverse the result of the adjudicator's decision obtained the previous year. And Donald Insel applied to strike out the professional negligence and breach of contract court proceedings, alternatively to stay them, unless payment of the judgment sum enforcing the adjudicator's decision was made within 7 days. And Mrs. Justice O'Farrell refused to strike out the claim, but did grant a stay. And the submission made by Donald Insel was interesting. It was said that the claim has been wrongly commenced without having discharged the payment required by the adjudicator's decision. It was said that constituted an abusive process and was contrary to law. And then it said this: a paying party is not entitled to commence a fresh claim seeking the determination of the party's true entitlements unless and until it has first discharged its obligation to pay the amounts determined as payable in a prior adjudication. And it referred to S&T and Grove, Devonport and Greer. So the substance of Donald Insall's argument was that S&T and Grove does not only prohibit the commencement of a subsequent adjudication to obtain a true valuation absent payment of the notified sum, but it also prohibits commencement of court proceedings seeking such a determination. So as I say, that was an original submission, but a submission that was, in my view, unsurprisingly rejected. There were two problems with it, as Mrs. Justice O'Farrell explained. The first problem was that S&T and Grove was about whether an adjudicator's decision should be enforced. But in this case, the decision had already been enforced, and there was a judgment enforcing it. So on the face of it, S&T and Grove did not apply. And the second problem was that in S&T and Grove, the question was whether the employer could commence a true value adjudication without paying the notified sum. But in this case, the question was whether the employer could commence legal proceedings, not an adjudication. And as Mrs. Justice O'Farrell explained, very different considerations apply, and that's set out in the second paragraph on the slide. So she said, unlike the adjudication provisions, which are subordinate to the payment provisions in the Housing Grants and Construction Regeneration Act, the right to bring legal proceedings to determine rights and obligations and seek remedies is more fundamental. The right of access to swift justice was guaranteed by Magna Carta and is enshrined in the Human Rights Act, which gives effect to convention rights, including Article 6, the right to a fair and public hearing within a reasonable time by an independent and an impartial tribunal established by law. A party's right to access to justice is not unfettered, but clear words would be required to make it subordinate to the payment provisions in the Construction Act. So fairly firmly disposed of that submission. But it is worth reiterating, as I said a moment ago, that whilst the court did refuse to strike out the true value court proceedings, which I think is unsurprising, it did grant a stay of those proceedings pending payment of the judgment enforcing the adjudicator's decision. So Q was not in practice allowed to pursue a final determination of the dispute without first paying the judgment sum. So that's everything from me, and your dessert is over, and that brings this jurisprudential feast and indeed Keating's series of webinars for this year to an end. Thank you all very much for attending and for listening. I hope you found that interesting, and the recording will be available later for you to watch should you wish. I hope you enjoy the rest of your day, and I hope you all have a lovely Christmas and New Year.